Thank you for joining us.
Thank you for having me once again.
All right, we'll pick up from yesterday. Then Maurice with some interesting aspects here, which we'll touch on as we move on with our conversation. But we'll pick some summary of what happened yesterday. Then we'll talk to Abdullah Mumi at the Supreme Court and get back to you. So let's just have briefly exactly what happened yesterday at the Supreme Court concerning the motion on notice for leave to reopen the case of the petitions.
All right, so good morning once again. And as you rightly pointed out yesterday, the main reason why the court sat yesterday was to hear a motion that was filed by the petitioner praying for leave to reopen their case to enable the chairperson of the Electoral Commission testify. That was how the motion was actually couched. So we saw that counsel for the petitioner argued that the petitioner was entitled to reopen his case because of certain exceptional circumstances that had necessitated that particular application. And these, he suggests, are the fact that upon closing their case, or upon examining their third witness and closing their case, the first respondent was also called upon to open his case, and they indicated that they had also closed their case and that these were the exceptional circumstances they were referring to. So essentially, what the petitioner was saying yesterday was that they had relied on representations made by the first respondent through the affidavit in support, the affidavit in opposition of the EC chairperson opposing the application for review of the ruling of the court not to allow the interrogatories, in which the deponent, that is the EC chairperson, indicated that those questions could be asked of her during cross-examination if the petitioner chose so to do. So the petitioner argued that he relied on this statement and acted upon it essentially to his detriment, because the first respondent had now decided not to call the EC chair to testify, therefore depriving the petitioner the opportunity to cross-examine the EC chairperson. And the petitioner relied in particular on sections 24 and 26 of the Evidence Act of 1975, NRC 323, which deals with what is referred to as conclusive or irrebuttable presumptions. And in law, when you talk about presumptions, there's what is referred to as presumptions, and they may either be conclusive or irrebuttable, or inconclusive or rebuttable presumptions. And presumptions are simply legal findings made from a given set of facts. So a typical example, for instance, there's the presumption of death, or that someone has died if that person has not been seen for 7 years by people who are likely to see or hear from him if he were alive. And so, given all reasonable search for him, it can be presumed that a person has died if for 7 years people who are likely to see or hear from him have not seen or heard from him. Another example may be the presumption that if two people, for instance, die in a car accident, the younger person is presumed to have survived the older one. And so the older one will be presumed to have died first, simply put. So the petitioner relies on the Evidence Act, Section 26, which in part talks about the fact that when a party has, by that party's own statement, act or omission, intentionally and this is the principle which is as estoppel by conduct, that you are stopped in your behavior, statement, or the consequences. So in a nutshell, what the petitioner was saying was that by virtue of the fact that the chairperson of the Electoral Commission, Mrs. Jean Mensah, in affidavits before the court on behalf of the first respondent, that is the Electoral Commission, that the first respondent had deliberately caused or permitted the petitioner to believe that the EC chairperson's statement that the interrogatories were not warranted, as she could be asked those questions during cross-examination, was true, and that he had acted upon the truth of that statement, and this should therefore be deemed to be a conclusive presumption in accordance with sections 24 and 26 of the Evidence Act.
Right, Doc. So, given that the witness statement and the affidavit sworn by the EC chairperson thereof, as we have come to know, is not in evidence yet, could those statements and the presentations made be seen as the truth, and so the petitioners will rely on that?
And that's why the respondents had the opportunity to respond. And the first respondent, for instance, opposed the application as being, first and foremost, an abuse of the court process, and that, in their opinion, sections 24 and 26 of the Evidence Act was inapplicable. And so the first respondent's counsel submitted, for instance, that no representation whatsoever was made to the petitioner for which he should be bringing this particular application, and that the statements contained in the affidavits deposed to by the EC chairperson was not in any case any representation whatsoever for which the petitioner should have relied, and that the petitioner at all material times must be deemed, and indeed is deemed, to have had effective counsel throughout the case. And so they should have anticipated that it was possible that the first respondent will choose not to adduce evidence. And it's clear, the Supreme Court has even given its ruling on the fact that the respondent in a case of this nature can decide not to adduce fresh evidence, or not to adduce evidence, or open its case for that matter. The second respondent also, on their part, opposed the application for a number of reasons. For instance, they talk about the fact that the petitioner was seeking essentially to adduce fresh evidence when they had closed their case, and essentially they were trying to come through the back door, seeking to reopen their case for the purposes of a subpoena to be issued. But for fresh evidence to be adduced or to be allowed, there was a certain threshold that the petitioner or a plaintiff in a civil case of such character needed to meet, and they believe that the petitioner had not met that standard or threshold for them to be given the opportunity to reopen their case in the first place.
Right, so Doc, I just want some clarification. So reopening of the case, and if the application of a subpoena is granted, will that amount to introducing fresh evidence?
So when you're reopening your case, or when you apply, first and foremost, it's discretionary, as we've seen. The petitioner is not unilaterally saying, I am reopening my case. The petitioner is seeking the leave of the court, praying the court to grant it the opportunity to reopen their case, essentially to cause a subpoena to be issued to compel the EC chairperson to testify. And so in that circumstance, or in those circumstances, essentially there is testimony. And I know yesterday the court did not necessarily go into the details of the subpoena.
Let's just hold on briefly for us here. We'll quickly go to the Supreme Court and get back to you. We'll just talk to Abdul Hai Mumin, who's standing by the Supreme Court, and get back to you. So just hold on for us briefly. We'll move to the Supreme Court and talk to Abdul Hai Mumin, who's standing by.
Today will be day number 16 since the Supreme Court started hearing the election petition brought to it by former President John Dramani Mahama, requesting the Supreme Court to annul the results of the elections as were announced by the chairperson of the Electoral Commission. Of course, we are seeing members of the NPP. That's Gary Nimako. He is the Director of Elections of the NPP, just making his arrival in court. And you recall in court because of some electoral disputes, the declaration of the results by the chairperson of the EC on the 9th of December. It's what has been challenged here by the petitioner. The petitioner is seeking the court to annul the results as were announced by the petitioner, I beg your pardon, but the first respondent, who is in this case the chairperson of the Electoral Commission. The point at which we are today, we've arrived here as a result of the fact that yesterday, almost throughout the entire sitting, the petitioner, through his lawyers, led by Mr. Chachuchikata, made an application to the court. And this application had to do with they being allowed to reopen their case following the decision taken by the first and of course the second respondents not to present any witnesses. Indeed, many were those who expected, even at that of the Electoral Commission will witness. Indeed, we were also told, even by some of the MPP persons so loyal to the second respondent, that Mr. Peter McMahon will be mounting the witness on behalf of the second. And so it took everybody by surprise when the second as well as the first respondents both indicated that they were not willing to put any witness in the box, given the evidence given by the petitioner. They were not convinced that the burden of proof had shifted from the petitioner onto the respondents. Now, following those decisions taken by the two respondents, the petitioner's lawyers then applied to the court to be allowed to reopen their case so they may be able to subpoena the chairperson of the EC. And in this case, the chairperson of the EC, per their arguments, is not a party to the suit. The EC is a party to the suit, but not as chairperson, as a person. And so the subpoena, they want the chairperson as an individual to be subpoenaed to answer questions in the court. The arguments and debates and counter-arguments took place in court almost throughout the day until the court rose. When the court rose, it indicated that it will convene again today to arrive at a decision. So we are in court basically to hear the decision that the judges will arrive at following the arguments they heard from both sides yesterday. And usually when the day sitting is over, we know that the first respondent does not make itself available for those press conferences. The petitioner and the second respondent's spokespersons, who usually speak to the media right after every day's sitting. And yesterday, both parties, and I'm talking about the petitioner and the second respondents, were very optimistic. They were upbeat that today's decision will go their way based on the arguments advanced by their lead counsels. It remains to be seen what impressions the judges make out of those arguments. Again, just to give you a background as to why we are here, for those who perhaps haven't been following this petition, on the 9th of December 2020, the chairperson of the EC made a declaration that may announce the president, Nana Dankwa Akufo-Addo, as president-elect. Then by the 10th of that same month, December, the EC had come with some press releases making some certain corrections to portions of the declaration. But effectively, the announcement was that the declaration, those corrections did not effectively affect the of course, I have Mr. Gabriel Asare Dako. We call him Gabi. He's here. So I need 2 minutes of your time. And sorry. Mr. Gabi, so you are a lawyer. We just need some education, even though we know that you're an interested party in this matter as well. Yesterday, we just want to break down the issues for the understanding of our viewers. So yesterday in court, the petitioner sought to seek the court's permission to reopen his case. You were opposed to that. Why?
Well, I think the reasons were pretty simple, in the sense that you brought the electoral commissioner and the winner of the elections to court. You opened your case, you called your witnesses. Even the petitioner himself didn't think it was necessary for himself to be in the box. He called witnesses, and the witnesses themselves, when you ask them questions about a petition and they don't like it, they can turn around and say, I'm not a petitioner. You said you were going to call 5, and eventually ended up calling 3. And you closed your case. And right from the beginning, I think on the 20th of January, the respondents filed a motion, which is that it was a preliminary objection asking the court to dismiss the case summarily. What it meant was that they felt that there was no cause of action. So that should have given counsel for the petitioner a hint that right from the beginning, these guys don't think that you have a case. So it's difficult for you to rely on the fact that they could in their case and you have an opportunity to examine them. That should have given them a hint, and it didn't come on just because it said that they will reserve that matter at the end of the trial. Objection which was raised by the respondents, the court did not act on it, said that they will give their ruling on it at the end of the case. But that should have told you that really they don't think you have any cause of action for them to respond to. So they were not likely to exercise that right to elect to produce evidence. So that really is the thing. And then when you tell us that you were relying on it, on an affidavit, what they said in an affidavit to an interlocutory application on your part, that when the opportunity comes, you can put these questions to them at cross-examination. I find it difficult because if you believe them, if you relied on it, then why did you file even a review? Well, of course.
But currently where we are at, it does appear the petitioner is seeking to use other routes to arrive at the same destination, the destination of cross-examining the chairperson of the EC. Now, the route is that the chairperson of the EC as an individual is not a party to this case and therefore can be subpoenaed to court.
Well, when you look at the Constitution, when it tells you about the Electoral Commission, it tells you that Electoral Commission is comprised of what? The chairperson, 2 deputies, and I think 4 other commissioners. Okay? So essentially, this law would tell you that when you see a corporate body, it is a person who is responsible. We could have brought the whole Electoral Commission to court. It is the chairperson who represents them. That has been the practice. So trying to make that pedantic, sedentary of an argument that it is the person. What is the person necessary? The person is necessary to you because she's the chairperson. She's the returning officer of the Electoral Commission. That's the only reason why she matters in this case. So you cannot try to then say that is the person that you want. because the person who is representing the Electoral Commission. So, well, let's wait and see.
Thank you very much. We hope to talk to you.
Your questions, your questions in the press conferences, excellent.
Thank you very much, and I hope to see you after that to ask you some of those questions as well, sir. That was Gabriel Asari-Ochudako, a member of the MPP. Is one of the very interested. That's Professor Jenana Opoku-Agyeman, the running mate to the petitioner, Mr. John Dramani Mahama, in the 2020 elections. She has been in court from day one. You would call that she happens to be the first female vice chancellor of any university in the country. She was the vice chancellor of the University of Cape Coast until she was appointed as Minister of Education under the administration of former President John Dramani Mahama, and she stepped up to become his running mate in the 2020 elections, the elections which currently is in controversy, which declaration is in controversy here at the Supreme Court so far. We are getting indications that the chairperson of the EC will soon arrive, Mrs. Jane Mensah, whose declaration on the 9th of December is in contention right now. And most specifically, the controversy appears to be around her and not around the second respondent's witness as well, because indeed it's not only the first respondent, in this case the EC, who has indicated that it will not present a witness. The second respondents have also indicated so. But it does appear that the petitioners are very much interested in getting the first respondent's witness, in this case Mrs. Jane Mensah, to be cross-examined, and not particularly so much interested in cross-examining Mr. McMenu. But it's also instructive to remind you that yesterday in court, the lead counsel for the petitioner did indicate to the court that he wanted a certain tape to be played, a tape in which Mr. McMenu, who is the witness for the second respondent in this case, was heard talking about some vote pardon, but of course the chairperson of the EC, Mrs. Jane Mensah, has arrived. Security procedures. Of course, she's here with her deputy commissioners. From day one, she's always been in court. She's here right now with her deputies. Of course, you see Dr. Bosman Asari is one of her deputies. Dr. Bosman Asari, once upon a time, was a lecturer in the political science department of the University of Ghana until he was appointed one of the deputies of the EC when Madame Charlotte Osei's regime came to an end. You recall that there were some petitions against the Charlotte Osei-led EC, which led to that administration upon which Mrs. Jane Mensah was appointed together with her other deputies ahead of elections 2020. Of course, before then they had also supervised district level elections. And you recall that there was also the issue of a referendum when Ghana had to vote as to whether or not we needed to create more regions. It was under the regime of Mrs. Jane Mensah and her deputies. But of course, we are in court today because the petitioner, Mr. John Dramani Mahama, is appealing to the court to nullify the results that were declared on the 9th of December, because according to him, none of the two leading candidates, in this case the petitioner himself and Mr. Nana Addo Dankwa Akufo-Addo, none of them attained the mandatory, constitutionally required 50% plus mark, more than 50% mark. None of them, according to the petitioner, attained this feat, this number that would indicate that you genuinely won an election, and that's what they have been trying to prove in court. and the case was filed on the 30th of December, given the constitutionally mandated time limit within which election petitions can be filed. But of course, there have been some significant changes since the last time there was an election petition in Ghana. In fact, the very first time in the history of the Fourth Republic that there was an election petition was in 2012, when Nana Addo Dankwa Akufo-Addo, Dr. Mahmoud Bawumia, as well as the late Jacob Bichebi-Lamte, who were the petitioners at the time, came to court to seek the court to reverse the results that were declared after the 2012 elections and declare Nana Addo Dankwa Akufo-Addo as winner of that election. Of course, we all know what happened. For 8 months, we were here at the Supreme Court for the panel to determine whether or not there was merit in the petition brought before it in 2013 for the 2012 elections. Of course, there have been very significant changes here. You'll realize that in this case the petitioner is just one, and that's because since 2012 different constitutional instruments have been introduced and nullifying, so to speak, some of the earlier constitutional instruments. We are currently operating under CI 99, which specifically speaks to election petitions and how they should be organized, and all the other issues around election petitions in the country. One of those is the fact that it is just one person who can petition, unlike in 2012 when we had 3 petitioners. That's number one. Then number two, you'll recall that in 2013, when the 2012 election petition was being heard, the petitioners actually sued, called 2 respondents, in this case the EC and Mr. John Dramani Mahama, in 2012. But the NDC then said they were an interested party in this suit because the candidate John Dramani Mahama had become candidate on the ticket of the NDC, and therefore if the NDC at the time was Dramani Mahama was being sued at the time, then it was only sorry, so I'll come to that point later, but I've just been joined by one of the lead spokespersons for the petitioners' lawyers, Mr. Tamaklo Eduji. Thank you very much, sir. So we realized that you applied to the court to be allowed to reopen your case. We are in court today, but for those of our listeners who still are confused as to what this is all about, what you are hoping to do, for the layperson out there, it's like you did not prepare adequately before coming. Now you've come to court, you've heard arguments from the respondents, you want to go back and now prepare to come and face them. Is that the case?
Absolutely no. That cannot be the case. The truth of the matter is that at the time we were closing our case, the Electoral Commission chairperson had put before the court a witness statement and has served us a copy. The second respondent had, through his witness, Peter McMahon, filed a witness statement and has served us. So as at the time we were closing our case, one, the chairperson had deposed to an affidavit when we came for a review in respect of the interrogatories. The affidavit in opposition was deposed to by the chairperson, whereupon she indicated that she will be taking a stand, and that when we get to that point, the 12 questions that we're asking, we could put it through her. If you recall, one of the justices actually asked Mr. Chikata that it is his case that those questions cannot be asked during cross-examination. Yes. So at all times we were prepared, except to say that we were taken when after we said we have closed our case, only for the lawyers for the first and second respondent to now say that even the witness statement that they have filed, they do not intend to rely on it.
So you have not been able to prove your case case at the time you were closing your case?
No, we have.
If you had, then why the insistence to have the first respondents?
No, I think that there is a certain misconception that as at the time you are closing your case, it should be the case that, oh, you had finished. Remember that our allegation is that the returning officer of the 2020 presidential election misreturned the election. She misreturned the election to the extent that, one, there were issues of vote adding. That has not been denied. Two, as we speak, there is one CI 135, which is the presidential declaration instrument, which has been gazetted. Under cross-examination, the second respondent lawyer actually said, quote, manifestly erroneous, the declaration on the 9th. If something is manifestly erroneous, what does it mean? Has there been any other declaration save the 9th one? So these are the issues.
Okay, so we know about a declaration on the 9th, but subsequently we also saw and read and indeed published press statements from the EC indicating corrections of certain minor errors, so to speak.
No. Has there been any other gazette? Has there been any other instrument? Unless, of course, you are telling me that you can use a press release to amend a constitutional instrument. It's never done. It's never done. So these are the issues.
All right, so we often do not want to preempt what the court will say. Well, we know that a decision will be taken today, and we hope to speak to you right after the decision. And that was Mr. Amaklo Eduji, one of the spokespersons for the legal team of the petitioner. And it's just about time. We will be going over to the courtroom soon. Mr. Abraham Amaliba is one of the legal team members of the petitioner. He's also just arrived in court, and when you see people arriving in droves around this time in court, then it indicates that even the judges are ready, and probably in the next few minutes will be making their presence in the courtroom for us to hear their ruling. So basically today, unless something else comes up, we basically expect that the ruling, the decision that the court has arrived at, will be read to the public, to the petitioners' lawyers, as well as the respondents and their lawyers as well. And after that, the court will then indicate what steps to take next. It's instructive to remind you that earlier last week, the court did indicate that all parties should present their written addresses by close of day on Wednesday, 17th of February, which is just tomorrow, so the court could reconvene on the 18th. Now that the petitioner has made an application, and now that the application had been heard, which was tomorrow, and now that we are expecting a ruling, it remains unclear what then becomes of the written addresses. Indeed, yesterday in court, Mr. Akoto Ampao did indicate that they would proceed, the respondents, at least the second respondent, would proceed to present its written address. However, he presented a concern also. That the concern was that the petitioners must not be allowed to see their address, no matter what the circumstances are. The court assured them that that would exactly be guaranteed, but so then it remains to be seen what becomes of the written statements if the wishes of the petitioner are granted today. But if the wishes of the petitioner are also not granted today, what are the steps that the court will then take next? Those are issues that remain unclear for now. As soon as we grab any of that information, surely we will make it available to you. Now, earlier we're trying to bring you an analysis and a comparison of 2012 petition and the petition of 2020 and some of the differences. We arrived at that point where I was telling you about the fact that in 2012 only Okay, so I'm getting indications that the courtroom is almost ready, and we have to move in there so that the ruling can be heard. But of course, we'll go to the studio now where Morris and George Sapo have been engaging other persons, experts out there, to further break down the issues. Then we'll return to court and hear the ruling. After that, we'll by all means be back here to break it all down for you.
All right, thank you very much, Abdul Haimuin. And whilst we wait for the justices to take their seats, we'll go for a quick commercial break. We'll be right back. Stay with us.
And they call me UJ. When you need a shoulder to cry, run on my pumping, so we try our suicide. Let bygone be bygone. I didn't see what the button gonna do. We go straight to start. I'm gonna take it to next level. My baby, oh yeah, yeah, yeah. The energy next level. My baby, oh yeah, yeah, yeah. Take it to next level. My baby, oh yeah, yeah, yeah.
I don't quote next level. Excessive drinking can be detrimental to health. Not recommended for persons under 18 years, lactating mothers, pregnant women, and people sensitive to caffeine. This advertisement has been vetted and approved by the FDA.
In Ghana, the environmental speed limit of 30 kilometers per hour should be observed in residential, educational, and commercial areas because human activity is dominant. 50 kilometers per hour is for built-up areas and communities along the highway. 90 kilometers per hour is for the highway. The Accra-Tema motorway has a speed limit of 100 kilometers per hour. Where there are no speed limit signs, the national and environmental speed limits apply. So, if you're driving near a school with no speed limit sign, your speed should be below 30 kilometers per hour, so you can stop your vehicle if you need to. Stop road crashes now. Stay alive.
This road safety education is brought to you by the National Road Safety Authority.
This advice has been vetted and approved by the FDA.
Ganabam, if your what apostle, your waist, all your body, you make bazaar.
Thank you so much.
Waiting here from doctor no. Where are they?
Yo,
oh my side. Mr. Tiabako. Ghana Bank, young to her. Mr. Tiabako, haven't you be 20 cities?
We need not have. Nemo, say we Ghana will come. Say I'm too so. If we can Ghana, you can.
And they call me UJ. Yeah, yeah. When you need a shoulder to cry, run on my pumping, so we try our suicide. Let bygone be bygone. I didn't see what I'm gonna do. We go straight to stardom. I'm gonna take you to next level. My baby, oh yeah, yeah, yeah. The energy next level. But baby, oh yeah, yeah, yeah. I'll take you to next level. My baby, oh yeah, yeah, yeah.
I don't Goodness level. Excessive drinking can be detrimental to health. Not recommended for persons under 18 years, lactating mothers, pregnant women, and people sensitive to caffeine. This advertisement has been vetted and approved by the FDA.
Don't forget the balloons,
check,
the DJ,
check,
and the drinks.
Listen, honey, I've got this party under control, okay?
Daddy, don't forget our birthday cake with the sparkly candles. Daddy, are you there?
The party's at 4 p.m., honey. Don't be late.
With the all-new CowPay on the CowBank app and website, you don't have to worry about carrying cash. Just place your order with your favorite merchant and pay with a Visa or MasterCard, mobile money or CowBank account, or scan and pay. Visit the Play Store or App Store and download the CowBank app today. CowBank app. Forget cash.
CowBank. Forward together.
The Ghana Trade Fair Company, under the Ministry of Trade and Industry and the One District, One Factory Secretariat, welcomes you to the 25th Ghana International Trade Fair, the premier virtual edition, under the theme, Developing New Trade Opportunities Through Digital Channels. It will be 1 month of exhibition and enterprise, offering manufacturers, suppliers, consumers, and various service providers the opportunity to network and make sales. This February, over 500 local and international exhibitors, factories featuring companies under 1D1F, Rural Enterprises Program, Ghana Export Promotion Authority, and more, all on one virtual platform from the 27th of February to the 28th of March. Get access to a virtual networking lounge, allocation of a virtual booth, and enjoy a unique virtual experience. Visit our website on www.straightfairgs.com to register or call 024-446-9451 or 050-001-5587. Don't miss out.
So welcome back. Is day 16 of the 2020 election petition hearing. We're still here in studio. Earlier on, our colleague Abduhai Momin spoke to some spokespersons, both for the respondent and the petitioners. So he spoke to Gabi Ochidako and Edujit Tamaklo, who is a spokesperson for the petitioners. We still have on the line Dr. Ajman Budu, who has been helping us understand this particular case in simple terms. We are live on Ghana Television and on GBC News. We are also live on Unique FM and on Facebook at Ghana Broadcasting Corporation. Doc, are you there?
Yes, I'm here, Morris.
All right. So there was this issue of you can subpoena a person and not a party. Can you help us understand this and how that relates in this particular case?
All right. Before we get to that point, I'm getting information, or there's information to the effect that a letter was written by counsel for the petitioner to address to the Chief Justice of the Republic of Ghana, setting out a number of things that they wanted the Honorable Chief Justice to consider before today's ruling. And so I believe that that's why there's a bit of a delay before the court actually sits. I'm hearing that the court will sit in about 30 minutes time or so, and this information was it's out there on other media platforms.
Sure.
That there was a letter to the effect that had to do with the proceedings yesterday that one of the justices talked about the fact that, or asked the question whether the ruling of the court on the objections earlier on in relation to the closing of the case of the respondents, whether that was not a bar,
a judicial bar,
the petitioner trying to reopen their case to subpoena the electoral commissioner. And I believe that the letter basically suggests that counsel for the petitioner wants to be heard on those arguments, or wants to argue those points before the court considers its ruling. I mean, this information is coming from sources within the precinct of the Supreme Court, other media personnel who are there, and I believe that's probably what's causing this delay and out there, so that people are aware of what is actually happening.
Sure.
And
but is it a practice that you can apply to be heard on some of the comments that the justices make? Is that a practice?
I didn't quite get the question.
I mean, what they are seeking to do, specifically to address what, I mean, the comments that one of the justices made, is that a practice? Are they allowed to do so?
I mean, throughout the proceedings of the court, or throughout proceedings in this particular petition, or the hearing of this particular petition, we've seen that whenever there's an application before the court, counsel who is moving that particular motion or has brought that particular application is allowed to argue his point out, or move the motion and then make his arguments in support of that particular application. And then the respondents are also given an opportunity to respond to those specific arguments. And sometimes counsel for the petitioner is given response that have been given by the respondents. And then once all is done and once he rests, then the court will decide maybe to ask further questions or to adjourn to consider their ruling and then give their ruling back. So that's usually the process that ensues before the courts generally. And I mean, this not being a motion before the court is simply a letter. That's the information that we're getting. That's if the information is true. It is a letter addressed to the Chief Justice of the Supreme Court of Ghana, the Chief Justice of Ghana, basically suggesting that they wanted to argue some points or something of that sort. That is not necessarily how the procedure is, like I've explained, and we've all been witness to in these proceedings, that once arguments come to a close, that is it, and the court will deliver its ruling. But of course, the Supreme Court is the Supreme Court, it is the highest court in Ghana, and they can, depending on the exigencies of the circumstances, they can take decisions and do take decisions that, in the opinion, are just in terms of the case or matter. Because remember, at the end of the day, the main reason why the court is sitting and hearing the petition is to deliver justice. And so when they believe that the justice of the case so demands, they may make certain orders or give certain directions that they deem fit to properly dispose of the matter.
All right, so now you want to answer my question.
Yes, and your question had to do with subpoenas, and what was the first part of the question again?
So you can only subpoena a person and not a party in a civil case.
So counsel for the petitioner, in response to the response that had been given by the respondents, both first and second respondents, essentially suggested or was suggesting that the Electoral Commission, or the first respondents, had chosen evidence has no bearing ever on the purpose of the Electoral Commission. So you draw a distinction between respondents, which is the chairperson Electoral Commission, which is Mrs. Gina Mensah. So that was the distinction he was trying to draw, especially in response to a statement, I believe, that was in the affidavit in the position to their application to reopen their case, where essentially the deponent was suggesting that because the first respondent had been essentially been affirmed in their decision not to testify or not to adduce any evidence, she was also barred from essentially adducing evidence. And I'm just trying to summarize what that particular paragraph stated, not that those were the specific words. But we also know that the Electoral Commission chairperson throughout these proceedings has been announced as the one representing the first respondent, that is the Electoral Commission. Sure. And I believe that was one of the things that the court went into. And if you remember, the Honorable Chief Justice read a portion of their earlier ruling which talked about the fact that the party, which was the Electoral Commission, could not be compelled to adduce any evidence, meaning they could not be compelled to call witnesses to testify on their behalf, regardless of the fact that they had filed a witness statement, which was the witness statement of the chairperson of the Electoral Commission, Mrs. Jean Adukwe-Mensah. So basically what the petitioner was saying in his arguments before the court yesterday was that there was a fundamental distinction between the Electoral Commission as an entity and the Electoral Commission's chairperson in the person of Mrs. Jean Adukwe-Mensah. So to the extent, even though that the Electoral Commission cannot be compelled to adduce evidence, for instance, the court cannot compel the Electoral Commission to by all means call Mrs. Jean Mensah to provide testimony. The petitioner was essentially suggesting that if they were given leave to open or reopen their case, could cause a subpoena to be issued to compel the chairperson of the Electoral Commissioner, who is quite distinct from the Electoral Commission, to actually testify before court. That was the distinction that was being made.
Did you say she's quite distinct from the Electoral Commission? So we want
I'm just summarizing the argument that was being made by the petitioner.
Right.
That the chairperson, as a matter of fact, the Electoral Commissioner is not necessarily the Electoral Commission. If you look at the Constitution, Article 43(1), it talks about the fact that there shall be an Electoral Commission which shall consist of A, a chairman, B, two deputy chairmen, and C, 4 other members. So the Electoral Commission, the commission itself is comprised of not just the Electoral Commissioner, but 2 deputy chairmen and as well as 4 other members, making 7 members of the Electoral Commission.
So in this case, there's a distinction between the person of Jean Adukwe-Mensah and the Electoral Commission.
That was the argument that the petitioner sought to make. The counter-argument, which I believe was made to some extent, was that even by reading the affidavit in the position, for instance, of the first respondent, seems to suggest that, and it's clear that right from the beginning, when the parties are called, we see that the petitioner is called and maybe Mr. Johnson Asiedu Keta is representing the petitioner. First respondent is called and Mrs. Jean Adukwe-Mensah is the one representing the Electoral Commission. Then the second respondent is called and Mr. Peter Makmenu is the one representing the second respondent. So at all material times, Mrs. Jean Mensah, who is the chairperson of the Electoral Commission, has been representing the Electoral Commission in these proceedings. And of course, the Electoral Commission, it being the first respondent, you cannot necessarily bring the commission as an entity. The commission is represented by individuals, being a corporate entity or being a body corporate. So that is why the chairperson is representing the Electoral Commission. So to that extent, or to the extent that the chairperson of the Electoral Commission is representing the Electoral Commission, then it seems as though their interests align one way or the other. That is a sort of counter-argument to the point that they are distinct, because you can see clearly that the Electoral Commission chairperson is a member of the Electoral Commission. But obviously these are arguments that are before the court or have been made to the court, and we believe that the Supreme Court will give its ruling on the issue and bring the matter to an end.
Right. So the petitioners have given indication that they will subpoena her to appear as an adverse witness. Is there any difference in cross-examining an adverse witness from cross-examining a witness who voluntarily mount the box? Does she have any immunity? Can she appear and say, I don't want to speak or something?
So an adverse witness, and I believe we talked a little bit about this yesterday, but weren't able to.
Sure.
An adverse witness simply can either be an unfavorable witness or a hostile witness, as it was referred to at common law. An unfavorable witness is simply a witness that may tell the truth or will tell the truth, but may not necessarily inure to the benefit of the party that calls that witness. A hostile witness, on the other hand, is a witness who may be hostile, for want of a better word, a witness who may not necessarily comply with what you seek to do, or may decide not to answer or be obstructive and things to that effect. And we know, for instance, that in Ghana, we refer to such witnesses as adverse witnesses, because if you look at Section 72 of the Evidence Act, NRC 323, it talks about the fact that the court can exercise its discretion in a civil matter either on its own motion or on the application of a party to call a witness whose interest may be adverse to the party calling that particular witness. And so it is possible that you would have an adverse witness. And when you have an adverse witness, one of the things, and that goes to the question that you are asking, that what's the difference between, say, cross-examining an adverse witness to a regular or normal witness. So, for instance, you will be able to, you need to obviously seek the leave of the court to be able to treat that witness as an adverse witness. So you may ask leading questions, and leading questions are simply questions which preempt the answer, or questions that you already know what the answer to, or preempt the answer by virtue of the question itself. Another consequence of treating a witness as an adverse one is that the credibility of the witness or any part of his or her testimony may be attacked. So you can seek to impeach the character of that witness, because essentially once an adverse witness is called, there's no examination in chief, for instance. Once the adverse witness is called, straight away, the party calling that witness and seeking leave or having been granted leave to treat that witness as an adverse witness will be engaging in cross-examination. And so that is where, usually there would have been the examination in chief, or the witness statement of that person would have been adopted. But for an adverse witness, we go straight into cross-examination at that particular point in relation to that adverse witness.
Right. Now, the adverse witness, can he or she also have a lawyer? Or in this case, the first respondent can also represent the adverse witness?
So what the rules or the law provide, that once an adverse witness or a witness is called and that witness is treated or leave has been granted to treat that witness as an adverse witness, the other parties are also entitled to re-examination. And we know that re-examination usually takes place after cross-examination, which gives an opportunity usually or normally for the party that has called that witness to be able to also clarify certain statements or seek to close any holes that may have been opened during cross-examination testimony of that witness. So what will happen is that once the adverse witness is cross-examined by the party that has called that witness, the other parties in the case will also have the opportunity to also ask questions of that adverse witness by way of re-examination. So it will be treated as though it was re-examination of those parties. The court may also ask questions of the adverse witness as well.
So at the point where the adverse witness mounts the dog, in this case, she will cease to be the witness of the respondent, right?
The respondents in this case have no witnesses. We know already that they filed witness statements, or they filed a witness statement, but chose not to call that person to give testimony and closed their case. So they have at this point no witnesses in this case. So, and I don't want to preempt anything that's going to happen, so I'll stay away from specifics. Assuming in a civil case that a plaintiff has closed their case, the defendant has also closed their case, and the plaintiff seeks the leave of the court to reopen their case, for instance, to recall a witness, because that's one of the things that can be done. You may recall a witness. The court even is given power to recall witnesses if it deems it fit and right, or the justice of the case so demands. They can recall a witness to examine that witness again if there is some pertinent information or clarification that the court seeks. The same way, a party may also seek to, for instance, reopen their case to recall a witness. And I gave a specific example the other time, which is premised on Order 38, Rule 3E5 of CI 87, the High Court Civil Procedure Amendment Rules, CI 87. And what that order provides is that it is possible that a party may have filed a witness statement in a case, but then choose not to call that witness to adduce evidence before the court. In that situation, any other party to the suit before the court may also then seek to introduce that witness statement of that party, even though the witness statement is not yet in evidence and as a result can not be relied on as evidence. The rule provides that the other party may introduce that witness statement as hearsay evidence. And they may do so, for instance, by recalling one of their witnesses so as to tender that witness statement to that particular witness. It's a possibility that can happen. So in a civil case of such nature, where a plaintiff seeks to reopen their case, they may do that. They may reopen their case for the specific purpose of, say, tendering in that witness statement, or may reopen their case to also seek the leave of the court to, for instance, compel some person to come and testify. And obviously, these are all discretionary matters that the court decides on the basis of the merits of the application before it.
All right, Doc, we'll go for a quick break. Just stay with us. We'll be right back. We're going for a quick break. I'm still waiting for the justice to get back so as for the ruling. But before that, let's go for a quick break. We'll be back. Yes. We'll be right back.
And they call me UJ. When you need a shoulder to cry, run on my pumping, so we try was suicide. Let bygone be bygone. I didn't see what the man gonna do. We dey go straight to stardom. I gonna take you to next level. Oh baby, oh yeah yeah yeah. The energy next level. Baby, oh yeah yeah yeah. I'll take you to next level. Baby, oh yeah yeah yeah.
I don't go that level. Excessive drinking can be detrimental to health. Not recommended for persons under 18 years, lactating mothers, pregnant women, and people sensitive to caffeine. This advertisement has been vetted and approved by the FDA.
Oh, today he has been extra sweet. And the way he looks at me.
I have done
everything by the book. It's on. Hey, but I have to get some condoms, Charlie.
Using a condom will protect you and your partner from HIV, STIs, and unplanned pregnancy. Condoms are an effective way for protection against HIV infection. Don't take risks. Use a condom every time. Always come prepared.
This advert is brought to you by Ghana AIDS Commission, Ghana Health Service, Planned Parenthood Association of Ghana, and the Adventist Development and Relief Agency, with funding from the Global Fund.
Michael, you're supporting the immune system. Yeah, Mama, Michael.
But you're what Tony here?
Let's not go be able to go in the
The cock supporting my boost for your immune system. Hey, I said a Michael t-shirt. My t-shirt. The pump of the front, I know. The t-shirt will go, Mama.
Boss, champion, Mr. Willie one.
Okay.
Michael, supporting your immune system.
I need your well-being.
FICO 20 is not suitable for children under 12 years of age, pregnant women, and lactating mothers. A quality product from Joy Herbal Center. This advertisement has been vetted and approved by the FDA.
A ruffle-wedded wife to having to hold from this day forward. I do.
Stop!
I knew it.
How much drama can you enjoy? See it feely with HD Plus. Get the best companion for your HD TV with HD Plus. Dial *879# to activate and enjoy the first 2 months for free.
This advertisement has been vetted and approved by the FDA.
Hey, good papa. Ganabam, if your apostle, your way, all your body, you make basa.
Thank you so much.
Good. What What are you doing?
I'm about hospital.
Ganabam. To wait here from doctor no. Where you there?
Epiao.
What must I do?
20 cedi.
This is Tiago. Ganabam. Yen turn to her. Every Saturday conti. Every chuobi 20 cedi. Hey. Nemo say we Ganabam come. Say I'm chuo. So so. It me Ganabam. Ganabam. You can resist.
All right, so welcome back. We're still waiting for the justices to make the appearance at the Supreme Court, and we'll hand you over to the Supreme Court as and when we get indications that the justices have arrived. We hear there has been a short delay due to a letter that the petitioners have written to the Chief Justice to hear them on a particular case which has to do with one of the statements that one of the justices made. In effect, she was saying that the ruling that they made on the 10th of February upholding the decision of the respondents not to present a witness to adduce evidence, some way, somehow, presents a judicial bar to what the petitioners are seeking to do now. That is, trying to open their case and subpoena the Electoral Commissioner to appear in the witness box at all costs. We still have via Zoom Dr. Kuku Ajiman Budu, who is a law lecturer. He's a lawyer first, a law lecturer, and head of Law Center's Gimpa Faculty of Law. Good to have you join us once again, Doc.
Yeah, yes, thank you.
All right, Doc, before we went for the break, we were talking about the adverse witness, and you said that the adverse witness will be re-examined by the other counsels or the respondent. Now, if the respondents don't have a witness, how are they going to re-examine? I mean, emphasis on the word re-examination, understanding what re-examination is also about.
No, so the point is that at the point where a plaintiff has, for instance, has applied to the court to seek leave to treat a witness as an adverse witness, at that particular point in time, that witness is examined as though the witness is being cross-examined. The witness is examined as though he or she is being cross-examined. And so once the party that calls the adverse witness, you know, under normal circumstances, you would call a witness who will be testifying to help establish your case. But it is possible sometimes that a witness that may help your case in some way may not necessarily want to testify or may be obstructive one way or the other. And that's why the law provides this idea that a witness may be treated as an adverse witness. So the interest of that witness may not necessarily be in line with yours. In actual fact, it may be adverse to your interest, you, the party calling that particular witness. So under those circumstances, the witness is not made to testify in chief or give his give his evidence, testimony, the evidence in chief, or even file any witness statement. That person is treated right from the onset when he or she is called as an adverse witness, if the court grants the leave for you to treat that person as an adverse witness. So once you are done with that cross-examination, because you called the party and the party was treated as an adverse witness, one whose interest was adverse to yours, your opponent or the party on the other side or the other parties in the suit will also be given an opportunity to re-examine that adverse witness. And so it's only just fair, it's part of the fairness of the court processes and procedures that when a party is cross-examined as an adverse witness, the other party is given an opportunity to re-examine that witness as well.
And this time around, the adverse witness, is the adverse witness allowed to have his or her own lawyer to represent her also in court?
It's not a question of having your lawyer represent you or not. It's as though it's similar to, for instance, when the court calls a court expert to an expert witness to give testimony in a trial, because there may be issues in play that are technical that requires an expert. So for instance, if the issues that needs to be resolved has to do with structural engineering, for instance, or mechanical engineering, and issues are that complicated, a court expert or an expert witness may be called by the court to give testimony that will help the court arrive at a conclusion, a just conclusion. It is in the same vein that if a witness is treated as an adverse one, the other party has the opportunity to also examine that witness. And even before that point, it's even possible that you, the party calling a witness, and usually witnesses that you call have to or will usually be called to help you establish your case, to give testimony that will make the existence of the facts that you are alleging more probable than not in a civil case, which may lead to the release that you're seeking being granted. It is possible that a witness you may call may turn out to be an unfavorable witness because, for instance, the testimony of the witness that you feel he would give may be to support your case, but he may come there and be telling the truth all right, but may tell it in a way that is not necessarily in support of your case. And that is what is usually referred to as an unfavorable witness. So even though you call him yourself, it turns out to be unfavorable to your case. So these are things that happen or can happen during trials or during hearings, especially within the context of civil cases, but also it could happen in criminal cases as well.
Right. So it will be a gamble if you called an adverse witness. I mean, you will be gambling if you do that.
It's a gamble calling any witness at all, because like I'm saying, a witness, remember, we said before that the Evidence Act clearly provides that a witness needs to, the only way in which you can testify, generally speaking, is that you must have personal knowledge of the matters that you're testifying about.
All right.
So the witness is the only one that has, obviously there are exceptions because there's hearsay and all that, which is second-hand testimony, not necessarily first-hand. So you may call a witness that has first-hand knowledge of the matters to which he or she is testifying, but the testimony the witness gives may end up not supporting the claims that you are making. So it is a gamble one way or the other when you're calling witnesses, because at the end of the day, regardless of the facts that you are alleging and regardless of the relief that you are seeking, you need to be able to establish by evidence what you are seeking the court to agree with you on and to grant you your reliefs. And the testimony of the witness as well as the evidence provided by witnesses are key. And so it is possible that your witness may not necessarily help you establish your case. It's a gamble that you take because the court needs the truth to arrive at the conclusion, and it is the witnesses who have personal knowledge of the matters to which they testify that will be called. So if the person turns out to be unfavorable, and it happens sometimes that you know what the witness is going to say, but he comes to court and starts saying something totally different from what you thought that person was going to say. Then you realize that the witness is either an unfavorable witness or an adverse witness, and you may seek the indulgence of the court to treat that person as an adverse witness.
All right. So we'll be talking about the 10th of February ruling, which ruling upheld the respondent's motion not to adduce the lead, the one, this is just engaging my mind. Under which circumstance would, say, Chachu or Akoto Ampao, say, today I'm not coming to court, and so let's say Tony Lita should take over?
I mean, it's possible. I mean, we are all humans, and it may be possible that, for instance, a lawyer in the case may not be feeling well, and so may ask his learned colleague or learned friend to hold brief for him in court. It's very possible that may happen, and so it's not something that is out of the ordinary or strange for that matter in court proceedings. It happens sometimes. There are numerous reasons why counsel may not be available, and so sometimes you would inform the court if there's enough time. You may inform the court ahead of time that you may not necessarily be available For instance, it's possible that you may have two cases that have been scheduled around the same time, one in two different courts altogether. And since it's not possible for you to be at those two courts at the same time, you may ask a learned friend to hold brief for you, or you may seek to have the case stood down for a bit so that other cases may be dealt with, and then subsequently when you come, you may conduct your own case. Or if he is apprised of the case and, for instance, works with you in the chambers or works on that particular case and thus is authorized to deal with the case, he may decide, or it may be decided that he can continue with the case on your behalf at that particular point in time. So it's not, and you may be sick. It's possible that you're sick and you can't physically attend court, and so somebody needs to hold brief for you. So these are things that happen. These are ordinary and normal things that happen. Even in our workplaces, sometimes you may be sick and you will not go to work or get sick leave or take a day off and things of that sort. Lawyers are no different than any other person.
Okay, so let's talk about that ruling that I earlier referred to. My understanding was that at that particular point where the respondents said they were not going to allow their witness to mount the box, the Supreme Court, granted them that at that particular point and said we cannot compel the witness to mount the box. Does it bring conclusivity to the issue, and that even after that ruling, there is no point in time that maybe a circumstance may arrive where there will be the need for the respondents to allow their witness to mount the box?
So if I get your question right, you are basically trying to, or asking whether it is possible for a witness. I didn't quite get the last part.
I was just asking whether that particular ruling brought finality, and so after that ruling there was no way that the EC chair could mount the box.
To answer that question, we need to understand what that ruling was in relation to. The ruling had to do with an objection that had been raised by counsel for the petitioner in relation to the first respondent and then subsequently the second respondent choosing not to adduce evidence and therefore closing their case. The petitioner was objecting that they could not do that, and that by virtue of the fact that the first respondent in particular had caused the witness statement to be filed and served on the parties involved in the case, they had elected at that point to adduce evidence, and they could not renege on that election. So the ruling had to do with whether or indeed, by virtue of the filing of a witness statement, a party is compelled at all costs to call that witness to give testimony. And what the Supreme Court said in its ruling was that on the basis of Order 38 Rule 3E5 of CI 87, the High Court Civil Procedure Amendment Rules of 2014, it was possible that a party that had filed a witness statement may choose not to call that witness to testify. And we know that the witness statement is not evidence until you have called the party making the witness statement, sworn the oath, and the statement adopted as that person's evidence in chief. Until that point, the witness statement is simply a witness statement and it is not in evidence. And so Order 38 Rule 3E5 gives latitude to a party to decide that, yes, I have filed a witness statement, but no, I am not going to call the witness to give any testimony, for instance, because on the basis of the evidence I have heard so far, there's no case that has been made out in the first place for me to even waste my time to call any witness or adduce any evidence on my behalf, and that the court should decide the case on the basis of the evidence they have before it, which generally would have come from the plaintiff at that particular point in time. So that is the context of the ruling. It specifically had to do with whether you can compel a party to call a witness at all costs simply because they have filed a witness statement. And the court held that the law was settled that a party will not be compelled to enter the witness box and testify in support of his or her case, and that it was a risk that parties who decline to give evidence take, knowingly or knowing perfectly well that the court will be left with no option but to proceed with the available evidence before it. That is the ruling of the court, and that is the context within which the ruling was given, specifically to whether when a party has closed this case, it must be compelled or it can be compelled to call a witness to testify on that party's behalf,
right,
simply because they have filed a witness statement. The issue now before the court doesn't have to do necessarily with that, because the court has given its ruling on that. The issue before the court now is that the petitioner is seeking the leave of the court to reopen its case. And then they, the petitioner, on the basis of the motion that they filed, want to cause a subpoena to be issued to compel the EC chairperson to testify. So it doesn't have to do with the other party being compelled to produce a witness to testify. It has to do with the petitioner in this case, or a plaintiff in a civil case, requesting to reopen their case for them to be able to subpoena a witness to testify in the matter. I hope the distinction is clear.
Very clear.
And
very clear.
Isn't the same witness we're talking about here with the earlier ruling and with this subpoena that might not actually be heard? Isn't it the same witness we're talking about?
Basically the same person.
Okay.
It's the same person that actually was the subject matter of the initial ruling. But the fundamental distinction was that this person was supposed to be a witness for the first respondent. And the application or the objection by the petitioner was that the first respondent was stopped because of the election they had made, and that the first respondent must necessarily call the EC chairperson to testify. What is being argued here is not the same thing. What is being argued here is that the petitioner, upon closing their case and upon the fact that the Supreme Court has ruled that they cannot compel a party to adduce evidence by way of calling a witness, the petitioner now is seeking to reopen their case so that they, the petitioner, can then call that person by way of subpoena to testify. That is the fundamental distinction between the two.
So it does not present a judicial bar.
Before we go into that one, let's go to Supreme Court now. They are just about taking their seat. We'll be right back. Over to the Supreme Court.
Rates number J1. Representing the petitioner. Samuel Ofosu Ambofu, my lords, represent the petitioner. Jane Mwensa, chairperson, is representing the first respondent. Mr. Peter Makmunu is representing the second respondent, lords. If your lordships please, I appear for the petitioner and with me my learned friend Tony Litha.
Please, my lords, Dustin Amenuvo appears for the first respondent. With me, Alexander Samoa.
It pleases your lordships. I put £1 for the second respondent. My lords, with me are my learned friends, Frank Davis and Quick West Rifi.
My lord, at the end, excuse me. I'm sorry.
Yes, excuse me. Please accept our apology for the delay in today's proceedings. We try as best as we can to be very, very punctual. We had the problems with the running out of the room, so thank you very much.
Yes. My lords, at the close, right at the close of yesterday, when I sought leave to respond to counsel for the respondent's submission, a question came from the bench in respect of whether, based on your ruling that you delivered on the 11th, whether the position that I was taking could hold. And I believe your lordship read a passage of your ruling at that point. My lords, we have respectfully sought your permission to have that matter fully argued, because it really came right at the end of the proceedings yesterday. And we believe that in the interest of justice, it would be appropriate that that important legal matter should be aired fully. And we have attached to our letter to your lordships, we have attached some of the authorities that we intend to rely upon in order to make clear that the position that we have taken, or that we are taking in respect of that point that was raised, is the legally accurate position. And we believe that it will be in the interest of justice that we all be given a chance to make arguments on the matter.
Counsel, with due respect, it's a legal point, and we've taken notice of it. Yes. So don't worry. It is a legal point which the authorities have been started. You certainly look at it. The ruling of the court. When the petitioner in this case closed his case with the testimony of his third and last witness, Mr. Robert Joseph Martin, on the 8th of February 2021, the court, as our procedure rules and trials provide, called on the first respondent to open his defense by the calling of his witness, whose witness statement had already been filed on the orders of the court. This witness happened to be the chairperson of the first respondent, Mrs. Jane Adukwe Mensah. Counsel for the first respondent told the court that he had made or scrutinized the case of the petitioner as presented by three witnesses, and in his view, the petitioner had not provided any substantial evidence in proof of his case, for which the first respondent had to mount the witness box to testify in answer. The first respondent therefore prayed the court to determine the petition on the oral testimonies and data presented by the petitioner through his witness and decide the main issue at stake, which is whether or not none of the 12 presidential elections did obtain more than 50% of the valid votes cast in the said elections. The second respondent, who was declared as winner of the elections by the first respondent, whose declaration ignited the filing of the instant the first respondent on his prayer and told the court he also did not desire to give any testimony through his attorney as contemplated. According to him, the petitioner did not discharge the burden imposed on him by law to produce sufficient evidence to buttress his case, so there was no need for him to say anything in explanation. He supported first respondent prayer that the court should resolve the petition on petitioner's evidence only since the burden was on him to prove the reliefs he is seeking. This position of the without adducing any evidence at all did not go down well with the petitioner. Counsel for the petitioner received this position of the respondents and prayed the court to compel the first respondent chairperson specifically to testify as first respondent witness since he had filed the will had elected to testify. As for the second respondent, petitioner said he was not bothered about his refusal to testify. The court adjourned for the parties to submit legal arguments for his determination of the matter, which they did. On the 11th of February 2021, the court dismissed the petitioner's objection to the respondent's decision not to testify and gave reasons in the written ruling delivered for that purpose. One of the reasons given by the court in dismissing the objection of the petitioner was that this court could not compel the first respondent to call his chairperson as his witness, as Group 3E, Subgroup 5 of Order 38 of the High Court Civil Procedure Rule CR 47 as amended by CR 87 permits them to do so. Immediately after the court's ruling on the issue, the petitioner filed the instant application. It was filed on the same 11 February 2021 and almost around the same time that this court delivered its ruling. This not to volunteer any evidence whatsoever. The petitioner did not hide and express it lucidly under paragraph 16 and 17 of his affidavit of the application as follows. Quote, 15. As a result of the ruling of the court of Thursday, 11 February 2021, it has become necessary, I am advised and very believe, that my counsel use the subpoena powers of the court under Order 38 Rule 10 of CR 47 to compel the attendance of the chairperson of first respondent to appear and testify in court. 16. At the time my counsel closed my case, the representation that had been made by each respondent to the court, and specifically to me, was that witnesses who had filed witness statements were going to testify. It therefore came as a surprise that both counsel for respondents announced on Monday, 8 February 2021 that this was no longer the case. 17. My counsel is seeking leave of the court to reopen my case to enable the subpoena referred to above to be served on Mrs. Jane Adukwe-Mensah so she can appear before the court to testify. End of quote. The application is headed Motion on Notice for Leave to Reopen Case of Petitioner to enable Chairperson of Electoral Commission to testify. From all indications, the target of the petitioner in this application is not the same respondent who has also filed a witness statement through an attorney, but the chairperson of the first respondent. The application, which is not known under our rules of procedure, has been brought under our jurisdiction as contended by counsel for the petitioner. According to petitioner, he is praying the court to reopen his case on his own instructions to enable him subpoena the chairperson of the first respondent to testify as a hostile or adverse witness. The petitioner advanced almost the same argument he made before the court during his objection to the closure of the respondent case. The respondent strongly opposed the application and have cited both local and foreign judicial decisions to support their arguments. Legal counsel for the petitioner urged the person of first respondent to testify as an adverse witness of the petitioner. Counsel also made references to paragraphs 31, 32, and 33 of the affidavit in support of the application as to why he wanted the chairperson of the first respondent to testify. The other point petitioner's lawyer kept urging on the court was that the chairperson performs an important constitutional duty and must be made to account to the people for her stewardship and to vindicate herself. The question is, how can the chairperson of first respondent vindicate herself when he is not on trial before us? He was neither being personally sued nor arraigned before this court on any complaint or accusation, civil or criminal, for which he was to explain or account to anybody for anything he has done or not done. It is the institution, the Electoral Commission, which he has, that has been accused by petitioner of not having performed its constitutional duty according to law. That the petitioner need the personal testimony of the chairperson of the institution before he could prove or establish the alleged non-performance of his constitutional duty by the first respondent. We do not think so. What indeed baffles this court is the intimation by counsel for the petitioner that he intends to call the chairperson of first respondent as an adverse witness. Black's Law Dictionary, 9th edition, edited by Brian Igana, defined a hostile witness as, quote, a witness who is biased against the examining party, who is unwilling to testify, or who is identified with an adverse party, also termed adverse witness, end of quote. A hostile or adverse witness, as the definition shows, as we understand the term in practice, is therefore a witness who has been called by a party to testify in support of his or her case and who, whilst in the witness box under examination in chief, performs hostile and gives evidence contrary to the party who called him and in support of the opponent's case. The party in such circumstances can apply to the court to treat such a witness who is already in the witness box as a hostile or adverse witness. This would enable the party calling him to cross-examine him as if he is a witness of his opponent to solicit the truth in respect of the issue at stake. A witness who has not yet entered the witness box to testify cannot therefore be called an adverse or hostile witness under any circumstances. The court exercises its inherent jurisdiction inter alia to correct errors in procedure and to ensure that no miscarriage of justice is occasioned during a trial. Inherent jurisdiction, which is also referred to as the inherent Prowess Doctrine, is the principle that allows courts to deal with various matters over which they have intrinsic authority. The petitioner has not demonstrated to us in any way that the decision of the respondent not to testify, which was upheld by this court in its ruling of 11 February 2021, has occasioned him any miscarriage of justice. That decision is backed by law, particularly our rules of procedure, case law, and settled practice. We demonstrated this in our ruling at 11 February 2021 when we rejected petitioner's objection to the respondent's decision not to testify. At the time this application was filed, petitioner had expressly closed his case, likewise the respondents. He is therefore seeking our discretion to reopen his case and to lead further evidence, which evidence he never disclosed to the court. He is not entitled to his prayer as of right. It is subject to our discretion, and before we can exercise our discretion in his favor, we must satisfy certain basic conditions as laid down by case law. The general expectation imposed on all litigating parties is to place the whole of their case before the court at the time of the hearing. The process of invoking the inherent jurisdiction of the court at the close of the case of the party to reopen a closed case in order to adduce fresh or further evidence is thus an extraordinary step which the importance of finality of litigation frowns upon, save the presence of exceptional circumstances. In the Canadian case of Oakley versus Royal Bank of Canada, 2013 ONSC 145, 2013 OJ, number 109, Supreme Court, MDJ held, quote, the court requires the parties to litigation to bring forward their whole case in both civil and criminal matters. The crown or plaintiff must produce and enter in its own case all clearly relevant evidence it has. On the other hand, a judge has the discretion to permit a party to reopen its case. This discretion, however, must be exercised judicially. It must involve a scrupulous balancing of the accountability of counsel for decisions regarding the prosecution of his case and the interest of justice. End of quote. Though this Canadian case is not binding on us, it has a persuasive effect as it espouses the principles governing reopening of closed case for the purposes of adducing fresh or further evidence. Back at home, our own Benny JSC, then Benny J, gave a similar holding in the case of Combat vs. Lambia, 1989-91 Ghana Law Report, page 324, at page 326 as follows. The general rule of evidence was that after a prisoner's case was closed, a judge should only call a fresh witness when a new matter had arisen as improviso, which could not have been foreseen. Said witness could, in a civil case, only be called with the consent of all parties. And although the evidence decree 1975 NRCD 323 permitted the court to call or recall witnesses, it was subject to the general rule. End of quote. Though the definition made reference to the calling or recall of a witness by the trial court, the same principle applies where it is any of the parties who apply for such a call or recall after the close of their cases. One of the leading cases on application to European cases is the Canadian case of 671122 Ontario Limited versus Argas Industries Canada Incorporation, 2001 SCC 59 to SCR 983 SCC, which was referred to as by counsel for second respondent. In that case, the court approved of a two-stage test, which was first articulated in Scott vs. Cook, 1970 OJ number 14872OR769. That test, which is intended to assist the trial judge in exercising his or her discretion to reopen the trial, requires the applicant to show that the evidence he or she seeks to adduce said that if it had been presented at trial, it would probably have changed the results. And two, prove that such evidence could not have been obtained by reasonable diligence before the trial. End of quote. This same test is what it has on further evidence in the trial or on appeal must satisfy before a court could grant such a request. In the case of Poku vs. Poku 2007-2008 Supreme Court of Ghana Law Report 996 at page 998, which was cited by counsel for the second respondent, this court, per Wood C, expressed the principle succinctly in the following words, quote, the rule is intended to assist an applicant who has made a genuine attempt to look for the evidence and has met with favor. Courts ought to be adept at unmasking attempts by a dissatisfied party coming through the back door and under the cloak of having come by new or fresh evidence, seeking to fill in gaps or lapses in his or her case, for the rule is not meant to aid the slothful or reckless litigant, whether acting pro se or through counsel. The application is not granted on commitment to give the sloven, particularly a litigant acting through counsel, carefully or fails to conduct his case properly by presenting essential evidence at the trial or through the necessary cross-examination, or also fails to conduct the necessary investigations which would have thrown light on or strengthened at 587 which was referred to the counsel for the first respondent, relying on the case of Young vs. Kenya and Betting vs. Shaw, 1989-81, law terms 531 and 532, Court of Appeal, held that the rationale behind the denial or grant of permission to order a new trial upon the discovery of further evidence must be the same as that which denies or grants permission to leave further evidence after the close of the case for the parties. In all the examples cited, the defendant did testify, and the plaintiff found the need to call for fresh or further evidence to buttress their case, though the courts, in almost all the instances, refused the applications. In the instant case, however, the respondent decided not to testify at all. So no situation arises for there to be the need for the petitioner to call further or fresh evidence to clarify anything, be it a doubt or a point raised in the testimony of the respondents, since there was none. The petitioner in his submissions made reference to section 26 of the Evidence Act 1972 NRCD 75 NRCD 323, which he says operates as a stopper against the first respondent for failing or refusing to call a witness as contemplated by the filing of